Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business. We provide information and resources that may help you manage some issues yourself, or on the other hand, you'll be better protected and better prepared to work with the professional counsel you select. Either way, of course, our goal is to help you save time, money, and achieve the best possible results. We once again and always welcome and thank our attorney, David Bazar, from the Bazar and Associates law firm in East Providence, as he continues to share his legal information and insights and anecdotes in each session. So today we're going to talk about product liability again with new cases, and because there are new cases that are in the news, others are being settled, some are just updated, some even are coming up with novel options. We've covered things like Roundup, Johnson & Johnson's, hip replacement, and a few others, but now there are others that are affecting families, perhaps your family. So we wanted to have this discussion because we think it'll be helpful to you. Amazon, your pharmacy, your convenience store, all are part of that distribution chain selling allegedly defective products, so we need to discuss them. Opioids that you have, the Zantac today with NDMA, vaping products, cannabis, it goes on and on. So, David, without going through the whole of it again, product liability, give us a quick overview of what it is, and then we'll get into some of those cases if you can.
Sure. So, product liability law was developed out of California, actually, originally. And so originally, without going all the way back, but in order to sue for something that happened to you and you were injured as a result of some product, you had to prove one of three things originally, either breach of an implied or an expressed warranty. So if it was a car that had some product, part of it that was defective and caused an injury, you had to prove that you had some warranty that was covered by this, or negligence on behalf of the manufacturer, whether it's a design defect or a manufacturing defect or a marketing or warning defect. So you had to prove either negligence or a breach of a contract type of action. And in California, they then added this idea of strict liability or strict product liability for the sale of a product that is inherently dangerous or unreasonably dangerous, and as a result of the product's danger, you're injured. So, for example, if you bought a chainsaw, which is an inherently dangerous product, and it didn't have a guard that should have been on it, and it was sold and designed and manufactured in that manner, then you would have a claim against the person who sold it to you, or against the distributor of that chainsaw, or against the manufacturer.
So you're getting into what ends up being that long arm that we start to talk about. There is a long line of potentially responsible parties, and that chain goes deep. So right. You mentioned the product manufacturer, somebody who makes the component parts, maybe someone who is the wholesaler or the retailer or the distributor right. or the marketer. So this is a very long... Right.
So it's commonly referred to as the stream of commerce. So all of the people who are involved in that product in the stream of commerce could be liable. So as you said, I'll give you another example of a case I had. It was a woman who was injured when a bottle of orange drink or apple juice disintegrated. And the bottle disintegrated because it was manufactured improperly. So we sued the person she bought it from, the retailer, the grocery store. We sued the company that put the juice in the bottle, the seller of the juice, the Lincoln Apple Drink Company, I think it may have been at the time, and the manufacturer of the bottle that they bought the bottle from, Anchor Glass Company. So all of those folks were liable to my client in the long run. But in that particular case, since the bottle was manufactured by a particular manufacturer, they took responsibility as to the damages owed to my client from the grocery store and the manufacturer of the drink itself.
So when they talk about the liability and some defects, you might have a defective product in the design of it, as well as the parts of it, as well as something along the production line of it. as well as how it's distributed and even how it's marketed because it might have a false claim or something? Is that,
there's
or not that?
a number of things that could fall into that. So the defect could be in the manufacturing process, and in that case that I had, it was the mold that made the glass was too hot, so the glass ran too thin, and so that was the defect. It could have been in a design, and so sometimes we have products that are put out in the market, and the design of them in and of itself creates a product liability case because it's dangerous, or the components in it, and without giving any weight to the merit, but Roundup might have a component in it that causes cancer, allegedly. So that design could be the defect. And then there is marketing defects, and those ones that I go back to are generally ladder cases where there were no warnings on them, not to step on the top step of the ladder. The ladder itself may have been designed correctly and was manufactured correctly, but there was a failure to warn that this is not safe to stand on this ladder beyond this particular level. So those are warning defects or marketing defects that aren't put in there, not intentionally, but in that case, an omission that should have been in there. You see it in cars when you get them all the time. When you put the sun visor down, there's warnings about airbags, this, that, and the other thing. So those are all warnings that it's been determined along the way that are appropriate and necessary to give to the consumer so that they're not injured by the product, even in the way it's manufactured and suggested to be used.
Does that help offset the potential of someone coming back and suing them? Does that warning, disclaimer, does that absolve them of
What doesn't
problems?
necessarily absolve them of a problem if the problem is different than what the warning is being given for. But certainly the warning is necessary to make sure that you don't have a claim against you for failure to warn.
For failure to. That's a good point. Good point of clarification there. So we're going to talk about some of the cases today. We had talked about Roundup. There are big verdicts, big settlements, and ongoing things. So Roundup has been in the news for a very long time. Even in Europe, we've talked about it before. Even here, they've talked about settlements. Same thing with talcum powder. And now, as recently as today, they're talking about Zantac. Zantac has been around for a very long time. It has NDMA in it, which is a potential carcinogen. And who's making the news? Not Zantac company, but right away, it's the drugstores that are distributing it. And are they now, by saying, I think we're going to stop distributing it, are they exempt, or are they going to be somewhat off the hook? Is it just a mitigating thing to the point where we're saying, how does it avoid it, or does it really do anything?
It can be looked at two ways, actually, but by taking it off the shelves, they are at least limiting liability to anyone else down the road. That doesn't really limit their liability to someone who's already bought the product from them, if that can be shown and proven. However, it's not necessarily an admission that something is wrong, although a plaintiff's lawyer could certainly look at it that way and should. But it could be looked at as, we're not 100% sure, so we don't want to take a chance, so that's why we're taking this off the shelves at this time.
So if you were the lawyer defending the Walgreens CVSs, if this did become a case, it would be your point that they did the responsible thing even before FDA, if they ever did pull it off the shelves or put the clamps down on the manufacturer, they did the right thing in advance, so please consider that.
Yeah, I would argue that if I'm representing them, we're being proactive. We're making sure that there's nothing out there that's potentially not safe, even whether we know or not. But why take a chance? We're going to do that, and let's see what the research plays out, because we're not admitting there was anything wrong with it. We're just being proactive.
Sounds right. So now the biggest issue across the country, and even other countries acknowledge this, we have a serious opioid problem. Pharma, big pharma, but Purdue Pharma in particular is being sued. They are bankrupt. They're claiming bankruptcy. And while that, I guess, is a story that many of us have followed, now considering there are so many others, manufacturers who have been involved with producing these kinds of opioids, that all of a sudden there seems to be a novel approach. Namely, they are piling on to what Purdue Pharma is doing with their bankruptcy case. theoretically, they're considering that even though each one of these individual companies is not currently in bankruptcy, that if they are able to pile on, it will absolve them from continued liability in suits. So they'll have to pay money, a lot of it, I don't know, that's not determined. Is that a new and successful way to handle possible settlements? I mean, obviously you're involved in those kinds of things whenever there's a case.
Right. So I'm not 100% familiar with what they're doing in terms of bankruptcy and trying to reduce liability or potential exposure through filing bankruptcy, because that's a whole different area of law. But certainly there is a lot of times in these situations, the companies try to get out in front of what their exposure will be and try to create pools of money and settlements so that they can almost settle, almost like a class action. Let's settle these
Yes.
up front with whatever the claims are and limit our liability through bankruptcy court and otherwise by doing that.
So from the legal perspective, David, if you think about each of these companies, I don't know what state they hail from, but each of them is being sued. So there's a state issue, then there's the big class action. I know that with product liability, every state has its own laws, and there's no federal product liability as it is. But go over the process of what would happen from each one of these states having to sign off or sign on to them participating in this. How is that going to play out from a legal standpoint, David? So many players.
Yeah, and those are different types of cases, really, as opposed to the individual's own claim for their injuries for personal liability from the product liability claim. If you think back to the tobacco cases,
Yes.
the big settlements were state claims against the tobacco companies, and every state wanted to and did participate in those types of claims. So now you have these new state claims in the opioid world and so forth, and it's where some states are saying we won't sign on to that and some
Yes.
will, and that is where a lot of that is headed. It's really not about the individual product liability claim, it's the claim the state has, for example, the health cost care and injury to the citizens of the state, that the Attorney General is prosecuting on behalf of his or her own state.
Right, so each individual state, plus whether or not the lawyers handling each of those state claims, plus the judges, whether or not they want to embark on taking on the whole now national. I mean, how is that going to play out? You have to have the, what would it be, Pharma, the Purdue Pharma would have to have that judge sign on and sign off on not just handling that, but incorporating 5 others. This is going to go on till we're 140 years old.
The tobacco litigation went on for a long time.
Yes.
This could, but it also by different actions that are being taken, Purdue filing the proactive bankruptcy type of filing, trying to force everybody into the same pool so that they will get a share of it, otherwise potentially get cut out. These are all legal maneuvers to try to get everything wrapped up and settled in a more timely fashion.
And if you're representing any one of those companies, David, and you know, obviously if you're working with them, you know what their sales are versus some heavy debt. Now if they are sued individually, it's going to be worse, but they're not claiming bankruptcy yet. Is that a good strategy perhaps to try to sign on? They won't have to be bankrupt then. They could just allocate some significant number of millions of dollars. Yeah. Is that a smart strategy?
Maybe billions.
Billions by the time that'll happen, sure.
Right, yeah. No, I think that's all part of the process. Is the defense lawyers for the company have to figure out what do we have available to try to settle these cases, what can we threaten or use as a threat to say, all right, first and foremost, they almost always are going to keep all of their defenses, that you would have in any claim or case. We didn't do anything wrong, the negligence isn't there, whatever it is that you're being sued for, you can defend.
Yes.
But they also have to, in this case, probably look at it from the perspective of some financial pressure to say this is all that's going to be available to settle this. Almost, it's not quite like it, but almost like a policy limit. This is how much money in an auto accident claims available for all the plaintiffs that were hurt in the accident. So you all have to come to the table and try to figure out how much out of this pot you're each getting. So there is a limit as to what they would have to pay before they are bankrupt. And if bankruptcy is the point or place where they are willing to go to avoid having to pay out more than they can, then that's what they'd have to do to protect themselves.
From a lawyer's perspective, David, you would have an ongoing case dealing with just that one company that you're dealing with. But once you end up signing on to this bigger, larger-than-life 5, 6, 7 company-wide, so what would happen then as to you as one lawyer representing one company? Suddenly, aren't you taken out of that picture entirely, or do you end up continuing on? How does that work?
Each company is still represented by its own attorneys and has its own defenses and things they can assert to protect themselves. So, but what they're trying to do is to say, all right, it would be like all of the tobacco companies joining together to say, here's the pot of money we have that's available that we can put up. Now, each one of those companies is going to try to limit what they're going to put up as opposed to the other company, and so that becomes an issue. But if you do group together, you can try to say, here's the pot that's available for everything. And do you want it, or are you going to force all of us down a different road? And not every company's in the same financial position, so.
So each individual lawyer is going to be working with his company, certainly, but also then with the other companies to figure out how to best tie into this.
Correct.
Sounds like, no matter what, it sounds like this is going to be yet another lengthy situation to deal with.
Yes.
So cannabis is in the news. We know more and more states are signing on for recreational. It's still a Schedule I drug, which means the feds don't approve of it. If you have someone who wants to be dealing with cannabis and you're representing them, can you and how can you, when you know you'd be dealing with someone who is dealing with a Schedule I drug that makes it illegal, even if it isn't a product liability issue yet, it's still a company that, how do they work with that, David?
Yeah, so that's not a product
No,
liability issue,
or
really?
at least right now it is.
Well,
we don't know what they put in the cannabis, but that's another issue.
But here's the deal with some of that, because I know there's been some question about Juul and some of their products. And some of the products that are being used that have some marijuana components in it, THC or something like that, are black market products. So in other words, a lot of those products have been bought not from a legitimate licensed dealer of that product. So what's in those products and what's involved, that's a whole different story.
Right, so vaping in and of itself may not have, it may have product liability because I'm not sure that wasn't whatever's in there in the first place is good for you. It has its own little tobacco and addictive nature. But now that you bring up the dank, I guess is one of the names, and there are others that are black marketed. If something's black marketed, isn't that automatically a problem with its product design, manufacture, components?
Well, what does black market mean? If it's something that you buy that's not legal to be sold, you're probably buying it from someone who's not a reputable person, not legitimate.
Yes.
So that's a difficult products liability case because there's nobody to go after necessarily. So as far as the other claims that may or may not be out there, I'm not familiar enough with them to know whether or not there is a legitimate product liability claim for using that product the way it's designed. And I know governors in many states have taken action to take flavored tobacco type products, I know they're not tobacco, but nicotine products, off the shelves because children are getting access and trying to use those. And they like that flavor. So it's not necessarily, it may be a problem, it's not necessarily a problem, but certainly a problem that children are using it, and that's why I'm sure the governors of those states are going after getting those products off the shelves because they don't want them marketed to children who aren't really supposed to be using them anyway.
So as you bring that up, I mean, that may bring up another legal issue, whether or not the governor can simply mandate that, and because the person who's selling it might have his right to, or his day in court and due process and whatever, but is something like Juul likely to have a marketing problem as a product liability claim? This is not addictive. This will not hurt you. Well, yes, in fact, there have been things put in that has been a problem, and it in itself, even if it's not tainted, has problems because people have had another kind of addiction. Are we going to be talking about another set of
I
cases?
certainly think that if Juul products follow the same course that tobacco products many years earlier followed,
Yes.
there could be a lot of problems. Again, I don't know the science of it, and I don't know, it would seem to me, I'm a layperson, I don't know, but putting vaped liquid into your lungs that might turn back to liquid is probably not a really great idea, but I have no science to that statement. I have no idea whether that's true or not true. That's what it took many, many years of research and study in the tobacco world to determine that what they were saying about their tobacco products were totally false. And the problem, what they had with those cases, the problem for the tobacco companies is they had research well in advance of
Yes.
the public knowing what they knew. And that's why they had such big, strong cases against them, because they hid the science, they hid the facts. And I don't know what the facts or the science is in this product yet. That remains to be seen. Does it take the same course as tobacco, or is it different?
So let's follow that or tease that out a little bit more. Right now, some of the states have mandated Juul off the shelves. Some who are still selling Juul, would they be wise, proactive, and limiting their potential exposure if this does play out, as it seems to be? Well, we took it out, like CVS taking Zantac off the market or whatever. Would it be a similar situation if they end up getting sued? They can say, we were proactive here.
Yeah, certainly it would be being proactive against future claims against people who came in, and they can't, in order to sue you for selling a product, you have to sell the product. Now,
Yes.
if you sold it to someone before that, that could be an issue, but it's so early in that whole research that I'm not sure, who's selling it, and is it the only thing they're selling, and does it, by taking it off the market, are they just closing?
I guess I wonder, too, how far back can they possibly go? They're talking about Zantac, we're talking about these Juul products. At some point, they might conclude this is definitively a defective product, cannot be sold, it's a carcinogen. But until that happens, it seems that they can be wise and take it off the shelves. But meanwhile, if they do go that, how far back can they possibly go? NDMA has been in plenty of other substances that are not being pulled off the shelves, and in some marginal amount it won't cause cancer, or it might. How do they retroactively go back? This could go back for another decade or so?
I don't know that you
How can that go?
necessarily do that. And there are statute of limitations and
Yes.
statute of repose and all
What's
of that.
that one?
So a statute
Describe
of
that.
repose is like a statute of limitation that says you have a certain number of years to sue for a defective product. And so usually the statute of limitations runs from the date of the injury. So I fell off that ladder on December 1st, 2016. I have to sue by December 1st, 2019 if it's a 3-year statute of limitation. But a product of repose says, the injury may have happened now, but what if that product was manufactured in 1899 and was designed to be run by water power and so forth and so on. So how far back should you be able to go to sue on that particular product? However, the other thing you raised was about, what if there is some problem with the product, whatever. Well, it was determined that there are problems with tobacco products, but they're still being sold with warnings. So who's to say that these products won't still be sold with warnings?
So let's talk about the marketing defect, if they're going to call that as part of product liability. How far do you get to go with marketing a message to get someone off the hook? You can just put a warning on absolutely everything that moves because we know it has a trace amount of NDMA. Use it at your own risk. Does that suddenly put a cap on how much they can do?
It depends on the product and the issue and all of that. So the Federal Drug Administration, FDA, whatever,
Yes.
oftentimes will tell them what they have to put on the product to let them know. So, for example, there's labels, I believe, even on alcohol products now that said pregnant women may, if they drink this, have birth defect issues with their child. There's the warnings that are on the tobacco products that talks about may cause cancer. So it depends on the product and the issue and whether or not it's determined that there's some reason to allow the product to be sold. It's versus being not sold at all.
Okay. With not cannabis, but rather the CBD products that are sold that allegedly will make you calmer but not head high, that's being circulated. Sometimes it's being advertised and put in print. If it doesn't make me relaxed, is that a product liability or false claim? Or is that a reason for someone to be concerned or think to sue?
Not necessarily, because not every product affects every person the same way. And if they can reasonably make the statement and it reasonably affects most people that way, then it may not be a case that you have because it didn't affect you that way.
So I say that just because there's a wide range of what is considered reasonable and certainly what isn't considered reasonable. When they're talking now about whether it's CBD or something else that's laced with pesticides, carcinogens, or whatever, those are, I'm sure, not part of the original product design.
Right.
So at some point it makes sense that they will be questioning that. When someone starts a product liability claim, does it actually start with just one person who thinks that they might have been harmed, or how does it actually start?
Most cases do. And most cases are individual cases that it's really what are the damages that that person suffered. And sometimes the information or what goes into that case can be used in other cases. So that's when you see these late night
Yes.
theoretical law firms advertising. If you've been injured by mesh or
Yes.
whatever else it is, call us, because they've got all the stuff that other lawyers or maybe they used in cases that have proven successful. Or sometimes they're advertising for these more class action type of suits or more cases that have settled where there's large amounts of money put aside in trust funds for settlement, such as
mesothelioma.
Mesothelioma, asbestos cases.
In the short amount of time we have left, would you consider that if someone brought to you what they thought is a product liability potential case, is it hard to evaluate whether or not they actually have a claim? I mean, some things are, as I've said, were very unreasonable. Right. Is it hard to evaluate that data?
It's actually similar to the evaluation that might go into a medical malpractice case, which is what are the damages and how far, how big were the damages and what do we have to prove that there was a defect in the product that caused the injury.
Sounds like there's something to explore there. We hope that this has been helpful to you, insightful perhaps, and we hope that you don't encounter products that have some liability, but we do thank you for staying tuned to The Law Matters, because as we say, it matters to you.